Good morning. Are you Jamie Story?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Ms. Story, in cause number 23, DCCR 1546, I have a motion to revoke your community supervision. Shows that you were placed on probation February 25th of 2025 for the state jail felony offense of theft of property with previous convictions, and that was enhanced to a third-degree felony because of some prior felony offenses. And it looks like the punishment was assessed at 10 years with a 10-year probation. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you failed to report to the probation department January 29th, February 12th, and February 26th of 2026. And is that true or not true?
No.
True or not true? Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
True.
Count 3 alleges that you failed to immediately report to the probation officer your contact information. And is that true or not true?
True.
Count 4 alleges that you failed to provide verification of performing the community service hours required. Is that true or not true?
True.
Count 5 alleges that you failed to complete the mental health assessment and follow all of those recommendations. Is that true or not true?
True.
Count 6 alleges that you failed to provide verification of completing the theft prevention class. Is that true or not true?
True.
And finally, count 7 alleges that you're behind in your court assessed fees. And is that true or not
True.
true?
True.
Did you enter your pleas of true to counts 1 through 7 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're all actually true?
Yes, ma'am.
I have here on the tablets some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow this agreement that you've made, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
And it looks like the agreement that you've made is for a cap of 6 years in prison, which means if I follow that agreement, I can give you 6, I can give you less than 6. It'll all depend on the information that's brought to me when we come back for a sentencing hearing. And is that what you want me to do?
Yes, ma'am.
All right, state tenders number 1.
No objection.
It's admitted any evidence Ms. Story is not competent.
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm going to reset your case for sentencing so that the probation department can do an updated report. Also, anything that you think is important for me to know, get that information to Mr. Rojas and he'll present it to me on your behalf when we come back. All right, you can go back with the baby.
All right, thank you.
Good morning. Are you Luciano Sevilla Jr.?
Yes, ma'am.
And Mr. Sevilla, the best you can, would you raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. You can put your hand down. And Mr. Parker, will he waive the formal reading of the motion?
You will, Your Honor.
Mr. Sevilla, in clause number 2239617, I have a motion to revoke your community supervision. Shows that you were placed on probation November 30th of 2022 for the third-degree felony offense of stalking. And that was a 7-year term in prison that was probated for 10 years. Is that correct?
Yes, ma'am.
The motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of criminal mischief, May 23rd of 2026 in Orange County, Texas. And is that true or not true?
That's true.
Count 2 alleges that you committed the offense of stalking, May 22nd of 2026 through May 28th of 2026 in Orange County, Texas. And is that true or not true?
It's true.
Count 3 alleges that you failed to, it's really the same.
It is, Judge. This was a motion that was filed rather quickly at the court's request,
That's
so
fine.
I put everything.
Yeah, no, that's fine. I appreciate that. I'm gonna skip 3. Count 4 alleges that you violated a term and condition of your probation by prohibiting the possession of a firearm, in that you were in possession or observed in a video displaying and possessing a shotgun and a red shotgun shell in November of 2025. Is that true or not true? Count 5 alleges that you violated the term and condition of your probation that required you to have no contact with the victim, Cynthia Gonzalez, And that on May 23rd of 2026, you sent text messages to Cynthia Gonzalez in violation of that order. Is that true or not true?
That's true, Mom.
Count 6 alleges that you are behind in your court assessed fees as of June 2nd of 2026 in the amount of $349. And is that true or not true?
That was complicated. I would always pay. I never had problems paying.
Well, it was just as of that date. So
Oh.
that's fine. I'll put not true for 6. All right. Did you enter your pleas of true to counts 1, 2, and 5 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
That's true.
All right, then I'm going to find that you entered your pleas of true to counts 1, 2, and 5 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation. But I'm not going to do that today. I'm going to reset your case for a sentencing hearing, ask the probation department to do an updated report. Obviously, if there's any evidence with regard to the firearm allegation in count 4, we can hear that. It shouldn't take too long if you want to have somebody here on that.
Well, Judge, and just so you're aware, I did contact Orange County DA's office last week. They do not yet have that case. In anticipation of these pleas of true or not true, I reached out to them, also reached out to Detective Taylor at the Bridge City Police Department. I would like to bring him at the sentencing regardless of these pleas for the court. I think it'd be important based on the fact that he's on probation for the stalking. It's the same victim, Miss Gonzalez, in both cases. I've handled it since the beginning of it. So if you would allow us a little bit of extra time, I'd like to bring that detective
Sure.
as well.
And we could do that on a regular morning
Yes,
docket,
that'd be
but
fine.
yeah,
Just
that would
you
be,
note, I'll have a witness or two.
okay. Do you anticipate witnesses?
That's my client.
Okay, so we'll just make a notation that there will be witnesses and maybe put this one at 11 for a sentencing, and we'll get an updated pre-sentence report. Anything that you think is important for me to know, get that information to Mr. Parker.
I'll give him later.
I understand.
Yeah, just you'll talk before sentencing, and he'll present all that to me on your behalf when we come back. All right, go back with the bailiff. Good morning. Are you Arlington Wood Jr.? And Mr. Wood, in cause number 25, DCCR 1650, you're charged with a 3rd-degree felony offense of failure to comply with sex offender registration requirements. That's from July 30th of 2025. The indictment alleges that you were also previously convicted of burglary of a vehicle, a 3rd degree, burglary of a building, a 2nd degree, another burglary of a vehicle, 3rd degree, and an unauthorized use of a motor vehicle, a 3rd degree, on January 27th of 1986. And after those were final, you were convicted of theft, a 3rd degree, January 22nd of 2019. You guys have marked off 2nd degree, but would
That
it
should
not
be
be a
first.
habitual?
It's not habitual because
It could be because they did not include in the indictment the underlying sexual assault offense that caused him to have to register.
Okay. So,
That would be a notice I would make
a
on my
notice,
own.
and that would make it a habitual, correct?
Correct.
So, Mr. Wood, I want to make sure you understand that if you go to trial and you're found guilty and the state files that notice of enhancement with the prior felony conviction that's not in this indictment, that you could be considered a habitual offender with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand? And I have a plea bargain rejection here on the tablet that you've signed with Mr. Parker that shows that the district attorney's office has made an offer. If you wanted to enter a plea of guilty, looks like to go forward probably on count 1 only for a 10-year term in prison. You have every right to reject that and have your case set for trial. I want to make sure you understand what the possible consequences are if you go to trial, what your options are if you want to plead guilty. Do you understand all of that? Sorry?
Yes, ma'am, I understand.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe that that offer would change, Ms. French?
Mr. Parker may have information for me that might cause that offer to change. Can we reset? How long, Mr. Parker? What do you say?
I mean, I don't know what I'm gonna provide you other than what I've told you. I'm not gonna have any documentation. I mean, with he's on parole, Judge. He has 2 types of cancer. He has some health issues and quite bluntly, he's, anytime he gets, he thinks is a death sentence. And so, I mean, that's his position, understand it. But I don't know if his position is gonna change.
So let's just do this. So, Mr. Wood, I'm going to place your case on the trial docket. If anything changes between now and then, the attorneys can let me know. We can get you back in here sooner. Mr. Parker has been appointed to represent you at this point. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney who could begin preparation for trial a little quicker. Is that okay with you?
Yes, ma'am.
All right, so Mr. Parker, you're released. Mr. Wood, we will appoint someone today. They should be out there to see you very soon to begin preparation for trial. Ms. Young, in cause number 24, DCCR 0402, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation January 6th of 2025 for the second-degree felony offense of assault on a peace officer, and that was a 5-year deferred probation. Is that correct?
Yes.
This motion alleges that you violated your probation. Count 1 alleges that you committed the new offense of hindering apprehension or prosecution November 18th of 2025. And is that true or not true?
Sure.
Count 2 alleges that you violated the terms and conditions of your probation by knowingly associating with and harboring Raimi Jamal Prevost. And is that true or not true?
Sure.
Count 3 alleges that you provided a urine sample April 9th of 2026 that tested positive for marijuana. And is that true or not true?
Sure.
Count 4 alleges that you failed to provide verification of performing the community service hours. Is that true or not true?
Sure.
And count 5 alleges that as of April 15th, 2026, you were $308 behind in your fees. Is that true or not true?
Sure.
Did you enter your pleas of true to counts 1 through 5 freely and voluntarily?
Yeah.
And did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker?
Yeah.
Do you fully understand them?
Yeah.
And do you understand if I follow this agreement that you'll be waiving or giving up any right to appeal?
Yeah.
And it looks like the agreement that you've reached is for me to continue you on probation, extend that probation 2 years, and also order that you enter and successfully complete the cognitive track of the ISF program. Is that your understanding?
Yes.
State tenders number 1,
No objection?
it's admitted. Is there any evidence that Ms. Young is not competent?
No, Your Honor.
All right, ma'am, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. This is a big opportunity that you're getting today. I'm going to extend your probation for 2 years. I'm going to order that you enter and successfully complete the cognitive track of the ISF program. If you do all of that, you're still in a great position because you can still finish this probation and not have a conviction on your record. But you're obviously going to have to make some better decisions. What's the relationship with?
That's the problem.
Your Honor, the court amended her probation several months ago, ordered her to not have any contact with Mr. Prevost. He is, I believe, awaiting sentencing or waiting disposition of a aggravated assault motion to revoke probation next door.
Okay.
He is out, and she needs to be aware that she needs to cease communication with him.
No.
I mean, if you were already told that, and I'm having to tell you again, then you're not going to be told a third time.
Yeah.
I don't care what the relationship is. It's up to you to decide if that relationship is worth you going to prison. So, because that's where you'll end up if you're back in here, you know? So I can't imagine that any relationship it would be worth that. I hope you take advantage of this. This was an agreement that I followed, so I'm handing you the trial court certification. And you'll go to ISF, and then when you're out, just do everything you're supposed to. All right?
For 90-day program.
Yeah, I think it's close to 90 days. All right, you can go back with the bailiff. Good morning. Are you Derek Shinkle?
Good morning, how you doing?
Good. And this is cause number 25 DCCR 1797. And Mr. Shinkle, we've gone through this before, but I'm going to go through and make sure we're all on the same page again. And in that case, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. And that's from October 15th of 2025. Your indictment alleges that you were previously convicted of possession of a controlled substance, a third-degree felony, October 16th of 2016. And what that means, sir, is that if you go to trial and you're found guilty, The range of punishment would be that of a first-degree felony with a minimum punishment of 5 years up to 99 years or life in prison. Do you understand?
Yeah.
And I have a plea bargain rejection that you've signed now with Mr. LeBlanc that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 6-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure y'all have gone over everything. You understand and you want to go forward with trial.
Yes, ma'am.
All right, well then we will get your case moved to the trial docket. Mr. LeBlanc will begin preparation. for
All right,
trial.
hey, thank you, ma'am.
Yes, sir.
You have a good day.
Thank you.